Hey guys, today let us see the topic called nature, definition and basis of international law. Before going to the topic, let us see what is law. We already saw the definition of law in jurisprudence. The famous jurist Austin told there should be a state. For state there should be a sovereign. Sovereign should pass the command. To enforce it as a law, it should be passed by the superior political authority. Then only it is called as law. When dispute occur within the state, then it can be resolved by municipal law or with the courts. But when dispute occur between two nations, two countries, then who will be the sovereign? There are two different countries, two different sovereigns, and who will listen to whose? So these question got arises. So the international law concept came into existence in 19 or 18 centuries. Before international law, war was existed in certain land, and it is done between two armies, and whatever the effects, it is only affected for armies. The civilians or common peoples in the kingdom were safe, and it was the war was existed for days together, years together, until one has to win and they have to come to the treaty or agreement. But nowadays, war is getting exited with 2 hours or within a day, like that. We already saw in World War II, America has dropped the atomic bomb on Hiroshima and Nagasaki. So two cities destroyed like anything, and it is fired up. So many common people got dead. Because of the dispute of two countries, the common people suffered. So the international law concept came into existence. After understanding the seriousness of nuclear bomb, atomic bomb, terror attacks, global warming, international law came into existence because it is not about one country issue. If nuclear bomb has dropped into two cities and only two cities destroyed now, but tomorrow if it is with a terrorist, then whole world can be affected. So to avoid that, international law concept came, where the treaties agreement will be done with the countries, like diplomatic relation, conduct of war, trade, human rights, sharing the oceanic resources. Like this, many aspects the law has developed according to the world, how it is going on. The law is also getting progressive. Now let us see the definition of international law, what jurist has said. Instead of reading word to word and memorizing the definition, let us know the concept, what jurists are trying to say from the definition. Here, Hugo Grotius is the father of international law. In his book on the law of war and peace, he come up with the principle of international law, and also he divided the law into two parts, that is natural law and positive law. Positive law again he divided into divine law and human law. Human law again he divided into law of nation and civil or municipal law. He's thinking more on positive law and progressive law, custom, treaties. But also he gave the preference for the natural law. But he is believed in progressive law, but not being rigid to the law what it is, but what it should be or what it ought to be. From that, he defined two principles, two main principles. That is, law is not imposed by sovereign, but rather derived from the principle. And principle includes promise must be kept. Once the promise given by the state should be followed. Jeremy Bentham is the first jurist to include the international law term in his book called The Principle of Moral and Legislation. Till now, no one has defined what is international law. The first person to define the term international law is LFL Offenning. According to him, he brought the concept called international law is a body of rule, customary law and conventional rule. But he considered it is the binding by civilized state. According to him, the same line many jurists has followed and restricted to the civilized states only. Like when we take about the J.L. Berry definition, he also told about the international rules and principle, but it is binding with the state. When we go for Grill, he said that international community and society of state. And when we take Gray's definition, he also regulate the conduct of state in their intercourse with each other. So all these authors are restricted to the civilized states. To extend this definition, Sir Robert Jennings and Sir A. Batts defined the state in wider perspective. States are not only the subject matter of international law but also the international organization, and some extent it goes to the individual, maybe subject of international law. So it is not restricted to the a civilized state. It is in the wider range. It is also applicable for the individuals, that is who are international criminals. For them also the law will be applicable is international law. Like this, the wider range they have defined the international law. Now let us see nature of international law. There is international legislation to create the treaties and conventional, and this international legislation is having the force behind it, and whatever the legislation that should be followed by the state, and state should be bound to those legislation created by the international law. And some jurists said that international law is not a real law, and some are criticized that it is a real law. That is based on the concept of sovereign of the state. Here, two different country, two different nation, and who is the sovereign? And due to this confusion and the criticism occurs. But we can say from the definitions, whatever we have read previously, international law is a real law, but it is weaker than municipal law. Municipal law is nothing but the law which is currently we are having. Municipal law, it is created ages ago, but international law came in the existence in 18th or 19th century, and municipal law applicable to the citizen when his birth taken place in that state, but international law applicable, so only state is binding to those laws, then only it is applicable to the citizen. So there is a absence of power to the court of international level, so it is weaker than municipal law. We can take an example like recently we saw Abhinandan, who was the war prisoner in the Pakistan. His flight got crashed and fell down in the Pakistan land, so he became the war prisoner. To get him back to our country, we have signed Geneva Agreement or Geneva Treaty. And so the war prisoner in other countries should be returned back to the home country safely and as it is without any harm.
Now let us see the basis of international law. According to the naturalist theory, law of nation or international law is only a part of law of nature. Law mainly derived from the morality, custom, universal principle, religious, etc. There are many criticism on this naturalist theory, so positivity theory came into existence. According to it, law made by the human. The famous jurist Jeremy Bentham follows the positive theory. According to him, international law is an agreement between the sovereigns, and it can be divided into two categories, that is public and private. Also, the former refers to the state, then the individuals. According to the consent theory, states should give the consent for the international law, and it should identify and acknowledge the rules which they are considered to be binding upon themselves. According to the auto limitation theory, states were independent and free agent. Accordingly, they can be bound by their own consent. Each state has their free will and its own sovereignty, so it can be allowed to implementation of international law on it. According to the fundamental right theory, man is entitled to be the basic right, like right to life, dignity. It should not be deprived for external causes like terror attack, atomic bomb, nuclear bombs. So the state should take the responsibility to secure the people of the country and to give the basic fundamental right to them. According to the Pacta Santa Servanda, this is the Latin maxim called agreement must be kept. For any agreement between the two countries or international law, that should be followed by the state without fail. Else, international organization or UNO will take action on them. The main objective of international law is to ensure peace and security in the world, to resolve any dispute in peaceful manner, to cooperate with each other, to strive for the better and brighter future of humankind, disarmament or withdrawal of weapons which causes massive destructions like nuclear or atomic bombs, to build the trust and confidence measures for the nation, taking collaborative effort to solve global problems such as terrorism, climate changes, refugees, crisis, etc. International law emphasizes on implementation of international treaties and conventional in right manner. Thank you.